lighter side. James Williams III is a convicted murderer who reportedly wanted easy riches through inheritance. Daniel shot his daddy 9 times, murdered his stepmom with a shot to the head. And the story just gets even more gruesome after that. It probably looked like something from a horror movie in that death scene that was going on there with the dismemberment and everything else. But he is out now. And your thoughts about this? I know that you have talked to a lot of constituents. Your overview of what happened, and in your analysis.
Well, first of all, obviously, the taking of any life, we regret, and we if it's an accidental thing, that's one thing. If it's an intentional act, there are laws that address how we approach that. Then once someone is arrested, tried, convicted, or pleads to a sentence, they're incarcerated in the Mississippi Department of Corrections for the time that has been appointed to them by that particular judge. The big concern is when someone becomes parole eligible, the parole board has to make a separate and unique decision of whether or not we're going to release this individual before they have served the entirety of their sentence. And so, of course, we have parole laws that cover that. This was a unique situation as it relates to generally the parole situation because he was under the age of 18, and there's been a lot of United States Supreme Court case law that follows that. Anytime that someone commits a murder, particularly 2 murders, and like you said, the facts and circumstances being just of a heinous nature, there's public outcry. There's outcry from, I'm certain, within the victims' families and sometimes even within the accused families or the one that's been convicted's families to be a great concern, number one, about the public safety of everyone else, and number two, has punishment been properly administered? Is it enough time? And if you take someone's life, how much time is enough time? And I think that often is a difficult decision for the judge. But this situation, I think, was impacted partly because he was under the age of 18 at the commission of the offense.
I was trying to figure this out as far as Luke Wooden. How old was he when he did that shooting?
I'm pretty sure he was under the age of 18 as well because he was a high school student. What we've had is there was a case in around 2014 called Miller v. Alabama. Went to the Supreme Court, and the just natural process of giving someone life imprisonment if it was a murder charge for someone over the age of 18 has been established, and it was okay as far as a legal standard under the Eighth Amendment not being cruel and unusual punishment. But the Supreme Court found in approximately around 2013 or 14 in Miller v. Alabama that if they were under the age of 18, and there's some interesting quotes, and I may read one of those maybe in the next segment just to kind of bring it home, that we obviously address the mental development, the capabilities of someone who's under the age of 18, that there should be a consideration that there should be a phase of finding guilt, and then there should be a separate phase of assigning punishment that would kind of give you a second opportunity to argue for something other than life without the possibility of parole. So you have a life sentence, but then you have a life sentence without the possibility of parole. In a circumstance such as that, someone wouldn't get parole. So that often gets confused as well. So after Miller came into being, there was a re-sentencing often of many people if they had not, kind of followed those guidelines that were laid out in Miller. And then ultimately there was a Jones v. Mississippi case that the Mississippi State Supreme Court decided, very similar facts and circumstances, I believe, the Jones.
But you're getting in the bushes with this, but I don't want to get too complicated. We never got to that, taking this to the courts, working its way up to the Supreme Court. I mean, it was never contested as far as any adjudication is concerned. This went directly to the parole board. They got a list of the people who fell into the 17-year-old or younger, and they chose this guy because apparently he had found Jesus. He went through the divinity program, and they made a selection on him. There was a lot of pushback. My question to you, as a noted attorney and also as someone on the corrections committee, do you think the parole board said, look, and I hate to say this, that personalities played into this, and I don't know Mr. Belk. I'm sure he's a good man, but we're all human. We just went through this Frederick Bell deal, and there was an outcry there. We're going to do this again. Who's going to control this board? We're going to make the decision, or are we going to let these people on media or some legislators make this decision? I'm damn tired of it. We're going to do it. We said we're going to do it. We're going to do it. Do you think any of that played into this?
I don't know. I obviously can't peer into his mind. I do know that the data shows that parole has plummeted for nonviolent offenses, which is a little bit confusing. In other words, drug offenses, the parole rate has plummeted under, Commissioner Belk's, tenure. But yet we've had now the second very violent murder that has garnered a lot of attention. I just brought up the under 18 part because that does have some United States Supreme Court implications.
I understand that, but I mean, it's voluntary. It's not mandatory that you have to offer this guy parole. I mean, the Supreme Court says the parole boards have to, they may have to put him on the list to at least see if he is eligible.
Certainly.
Or they think he's no longer a risk, but they didn't mandate that they parole this guy.
That's right. I just wanted to make sure a couple of things were clear.
I understand.
That's the law as it relates to the Supreme Court. Number two, the last two, in 2014, House Bill 585, and then in 21, there was a parole bill. Neither one of those mandated this either. This is something that was already
Isn't
in play.
That part of the problem why we're talking about this? Because there are so many red flags in here, so many other people that could have been chosen for this, so many questions that Mr. Belk or any of the other parole board members refuse to answer. Not that they have a responsibility to do this, but every time we brought up a question of, is this guy rehabilitated to the point from really a gruesome murder, serving only 20 years, is he ready to go back into the community, number one? And if so, what about all the other people that came? Why this guy? And if you'll remember, Tate Reeves appointed Mr. Belk, and he told him go fix it because the parole board was in disarray, and he told him to go fix it. This is not how you fix it, though. Not because you just added some validation to this when you just said that there are other people out there with lesser crimes.
And I've expressed that directly to the parole board chairman and to other members of the parole board, is just to point out that, look, our bills the last few years we've pointed out we're trying to deal primarily with drug offenses, and what can we do to help with rehabilitation, reentry, having them in the workforce. We have that discussion all the time. Then we talk about people that are violent, people that we are afraid of, people that we feel like are a public safety issue, and that is a different discussion. Of course, Governor Reeves makes many appointments. He makes the appointments to the parole board. The Senate confirms. I can assure you, if there was a confirmation hearing for the parole board chairman again, there would be a lot more questions this time than there were last time, because I want to know what's your philosophy, now from each decision. I can't, nor can the governor, second guess the parole board or go tell them, no, you can't make that decision. But it is a little startling. It's a lot startling when nonviolent offenses are not being paroled at the rate that they were, and it appears as the intent of the legislation. But yet we're having these violent offenses.
Here's what we're left with at the end of the day with the many people that we've talked to about this. Parole board makes a decision. They don't have to make a decision whether the guy is fit or not. They don't have to interview anybody about this. They don't have to tell anybody when he's being released or where he's being released. On some of the criteria as far as having the family there, making decisions based on what the family's needs are, that doesn't come into play.
It should. The law says it should.
All of those things.
Yeah, we can talk about that, but it should.
Well, let's talk about it because it seems there was as many or more infractions of protocol in this one than the prior one as far as Mr. Bell's concerned. So nobody understands this, but we'll continue the conversation in just a moment. Wants to record to put on the market, so there you go. Back with State Senator Daniel Sparks. Continue, sir, because we were talking. Let me ask you one question. Have you talked to Tony Smith, who resigned from the parole board?
I have not talked to Tony since he resigned. Tony and I talked pretty regularly while he served on the parole board, and I talked with other members on the board pretty regularly, just trying to address what we have seen as a problem of just the the lack of nonviolent offenders really being taken seriously, and often many of those being set off past their term. But I will talk to Tony, but I have not talked to him.
You talked to Chairman Barnett, Juan Barnett, about this?
We've not discussed this specifically. The big issue, and I think it goes back to what you said earlier, I will want to know, and I think there will likely be a hearing just to make sure we're following the law, because or when I say we, the parole board, the law clearly states the victim or designated family member shall be provided an opportunity to be heard by the board before the board makes a decision regarding release on parole. The board shall also consider any restitution ordered has been paid in full. That's new language that came in the parole bill that we passed a couple of years ago. We mandated there be a hearing, and we mandated not a may, but a shall. The family shall have a chance to be heard. So if those protocols were not followed, I certainly believe the victims, law enforcement, DAs, they have the right to weigh in on the parole decision. There's one other thing about parole I want to make sure everybody understands. When I parole out, I have to serve the remainder of my time while outside of the prison. I'm still on parole. A life sentence doesn't end. So any violation by someone who's out on parole with a life sentence, they would go back and complete the term of their sentence. While I certainly hope, and I believe the parole board would have tried to have evaluate to see if this person's safe to go back into society, for any parole violation, this individual could be revoked by the same parole board and sent back to prison to finish their life sentence. So there is that at least.
I was looking at some crime stats that I believe these came from Shad White yesterday on Gerard's program. I believe it was yesterday. Public believes 61% of prisoners' population consists of nonviolent drug offenders. Actually, in prison for drugs, is only about 22% of Mississippi jails are occupied by the demographics. So it's not like everybody in jail is for a small amount of marijuana or something. In addition, the average freed criminal, this goes back to what you were just saying, the average freed criminal is locked up again between 10 and 12 times after his or her initial stint behind bars.
And there's a deeper discussion in that. Number one, we need to make sure our parole and probation officers are allowed to do their job, and they're not doing the job of a correctional officer. We've got way too much focus on our parole and probation officers being called in by MDOC, not actually doing the job they're doing. That's a separate issue for another day. Mm-hmm. But as it relates to the nonviolent offenders, now property crimes are nonviolent offenders. I don't want anybody stealing my weed eater. I don't want anybody in my building out back trying to steal my lawnmower. But a lot of that goes back to a drug problem. We've tried to utilize the intervention courts. We want to continue to do that. And I'm a firm believer in crime and punishment. That's the way I was raised. There were swift consequences for violations. But we have to be, smart about it in the sense that if we have people that can be gainfully employed and they're not a threat to the community, we need to try to get them some assistance. But the 22%, I can't dispute that with my own data, except to say if all you do is call it a drug offense, you may have somebody that's in there on a property crime that the source of it is his drug problem. No. But we're looking at a situation where somebody has gone through a program, and I want to be very clear about this. The good Lord can save the worst amongst us. That's not the question. I want to make sure that that's not lost in translation. But because I've completed a program, does that justify my release? I think that's a decision the parole board better take and weigh very heavily, because if someone who's on parole commits an offense, that would weigh heavily on me if I had a hand in their release.
Apparently, I guess, was that the determining factor in all of this? Because he went through not so much the Supreme Court, which brought it to the table, right, but to justify it. It seems to me that was the justification for this whole thing. He went through a divinity program.
When you look at the beginning of the parole legislation, it talks about someone who's incarcerated from a year to a period of life, and they look at the behavior once they enter the system. For 20 years, I don't know the man's program or behavior. I don't know if after coming to the prison he recognized his ways. I don't know if he had a drug problem. Don't know if he had a mental health problem. Don't know. I know that he took 2 lives. But if he has a 20-year track record of behavior that is good, I think the parole board is going to look at that if that person is otherwise parole eligible. That's the consideration. I don't know that that's the simple factor, but
if he killed 5 people, but he was okay in 20 years, would that have a factor?
I think all those things are a factor. The biggest thing to me is
I would think so.
Yeah, let the victims have their say. We ordered that in this legislation.
If Charles Manson, I'll give you the final word here. About 15 seconds. Go ahead, sir.
I think you're on the right path. I think we need to answer these questions because we need confidence not only in the criminal justice system, we need confidence in the parole system.
I thank you for coming in. I appreciate it so very, very much. I think we're going to hear a lot more about this, and I think next year there's certainly going to be some talk in the 2024 legislative session. State Senator Daniel Sparks, thank you, man. Appreciate it very much.